SJC 12455, Commonwealth v. Juvenile.
Ms. Celli, good morning.
Good morning. May it please the court, Melissa Celli for the Juvenile. Also with me today is Julianne Feliz-Kidd. She is the Juvenile's trial attorney. The bail order in this case is unlawful for 3 reasons. First, the judges failed to consider other non-financial conditions to secure the juvenile's continued presence at court appearances. Second, both the juvenile court judge and the reviewing superior court judge failed to justify the specific dollar amount of bail set. And third, both judges used the juvenile's status as a DCF-involved youth as a reason for detaining him.
What happens if a juvenile is charged with trespass and they're in DCF custody and the judge imposes a $1 bail?
Your Honor, I don't actually practice in the juvenile court, but it is my understanding that DCF does not pay bail. Again, I don't practice, but I will say that the practice of DCF not paying bail is apparently widespread enough that there is a YAD advisory on the matter informing the Youth Advocacy Division attorneys that DCF does not, in fact, pay bail.
Let me ask you about your argument that the judge failed to consider alternatives. Judge McGuire, at least on the Superior Court review, said he considered the Brangen factors and set bail.
So he considered that the juvenile was unable to pay this bail, but there's no indication.
My memory is he cited Brangen. He said considered it, right?
He did cite to the decision, but
So we think that Judge McGuire got it wrong, that he didn't understand what Brangen means?
well, I think that Brangen made it clear that the setting of unaffordable bail is not just a matter of procedural due process. This isn't a matter where you can just say that you've cited Brangen and...
Difference, though, isn't there, between bail that's unaffordable without being considered with regard to the person's financial situation or circumstances, and bail that may still be unattainable but has considered that? The judge still has discretion to make that determination, correct?
Absolutely. But what the judge didn't do here is consider the fact that any bail whatsoever was unaffordable for the juvenile.
So you believe that there should be a finding, for instance, of why GPS wouldn't be adequate or why home arrest wouldn't be adequate based on the language of Brangen?
Or at least that those alternatives had been specifically considered and rejected. And in this case, that didn't happen. I think that this is illustrative of the difficulty that juvenile courts are having in applying the Brangen decision. In the adult context, perhaps using a variable dollar amount for bail makes sense, where the adult at least plausibly has some financial interest in the bail. So I think judges are used to considering the factors of flight risk and setting a dollar amount lower or higher depending on the flight risk. But in the juvenile courts, that calculation really doesn't make the same amount of sense, because in juvenile court, the defendant is a juvenile who, by definition, is indigent. At least in the case of DCF children, almost certainly the child is indigent, but probably with respect to all juveniles. And so using this variable dollar amount just doesn't make the same amount of sense in the juvenile court as it plausibly does in the adult court.
So you'd be making the same argument if he had set $500 bail or $100 bail?
I think I might be, because there's just no justification for a specific dollar amount, which was what was required by Brangen. Brangen required consideration of other non-financial means to secure the juvenile's presence in court, and also a justification of why that dollar amount is appropriate to.
So do you have a recommendation for us, a specific concrete recommendation as to what would make sense practically, taking into account the needs of both sides of the equation?
Your Honor, I think that the amicus brief did a very nice job of laying out a pretty specific set of findings that needs to be made, and I would support that. I think that the difficulty with juvenile court is that when you're dealing with it, by definition, indigent juvenile, really any amount of bail is going to be a detention order, for the most part. There might be exceptions, but for the most part, juveniles are indigent, and in particular, DCF juveniles are indigent. So it's impossible for a judge to justify, say, a dollar bail versus $50,000 bail. So using the dollar amount as the variable for considering the severity of the flight risk just doesn't make sense. Instead, in the juvenile court, what makes sense is to use the alternative non-financial conditions of release as sort of the variable that the judges would use to account for the severity of the flight risk.
But in this particular case, the juvenile was on the run to begin with, right? So we know he's a flight risk.
Well, but I would say a couple of things to that point. It is true that he had been on the run. However, first, is one instance of running sufficient to justify a very lengthy, at this point, pretrial detention? And second, did the judges specifically consider things like increased probation check-ins? Did they solicit input from the DCF social worker about why it was that this child was running, or whether an alternative placement could be secured that would do a better job of ensuring his presence? None of this is on the record. It's possible that if this case goes back down on remand, that the juvenile will nevertheless be detained pretrial. That is a possibility, but the fact of the matter is we don't know, because the record is not well developed on this point in contravention of Brangen.
Well, Brangen certainly recognizes that you can hold somebody knowing that they can't afford the bail. So in the juvenile context, we can assume that this is essentially a detention order. And your point is that it could have been a smaller amount of money, been a detention order, but it is ultimately a detention order. What do you say a judge must do to satisfy Brangen? Must the judge set forth each of the possible alternatives and say, I considered 1, 2, 3, 4, 5? Is it sufficient to say I considered various alternatives? Is some colloquy? What you're asking for? What are you asking for?
I think that the judge at the juvenile level needs to, at the very least, solicit input from the DCF social workers or the DCF guardians to find out, to be able to make an individualized determination about why no less restrictive means are available and or would ensure the child's presence. I think that without soliciting this sort of input, you're not only not fulfilling the due process requirements of Brangen, but you're also placing DCF children at a disadvantage vis-a-vis their peers who have parents who are there to advocate on their behalf, who have parents who will come in and say, we're going to ensure that this child makes it back to court. DCF children don't have those same protections.
When the bail decision is being made, at that point you said solicits information from the social worker or the guardians. Are they typically present in court, or is there special arrangement?
It is my understanding that they are summoned in as the juvenile's guardian for arraignment. That is my understanding.
So you would be satisfied if the judge had made inquiry and then ultimately said, having made inquiry, I'd conclude that there's no reasonable alternative to this bail.
Well, I would maybe take it one step further and say we have or if the judge said, I have considered all of these alternatives and I have concluded that nothing shy of detention will hold this youth. Okay,
but you would not be requiring findings to say, I've considered. You would want a colloquy, but you're not saying that the findings must say, I've considered A, you can't do A, I considered B, you can't do B. You want that to be part of the earlier overall colloquy, and then you can summarize your conclusions, or you're asking for there to be detailed specific findings as to each of the alternatives?
I think that at the very least there needs to be an acknowledgement. Perhaps if there was a standard list of alternatives that was proffered by this court or the legislature, and then the court could say, I've considered all of these, but in the absence of a detailed list, I think they do need to discuss what specific factors and
But we issue a case and we say, here's what the judge should consider. The judge has a hearing, says, I considered this case and I set bail anyway. You want us to say to the trial judges of the world, well, that's not good enough. Here's a checklist. Tell us how you did what we asked you to do.
Well, I would say that first we're dealing with juvenile courts versus the adult court in Brangen, where again, there's a logical basis for setting, say, in this case, a $50,000 bail. You know, you can assess what the adult defendant could pay versus, you know, there's a level at which you cross a boundary from affordability to unaffordability. I think that just doesn't exist in the juvenile courts. And so I think that, yes, in fact, in the juvenile courts, the courts do need a list of alternatives. They need some variable that they can use rather than the dollar amount of bail, which is used in the adult court.
This may be in the record and maybe I missed it, how many juveniles are being held right now because they can't make bail, or how many are pending who did make bail, or anything like that?
I don't have that information off the top of my head, but I believe, if memory serves, that the amicus brief did touch upon that.
Okay.
Okay, thank you.
Thank you.
Mr. Nadeau.
Good morning. May it please the court, Steve Nadeau on behalf of the Commonwealth. Your Honor, it's clear that both the juvenile court judge and the Superior Court judge on review understood that the bail order in this case would amount to a de facto pretrial detention order. That's why they made the written findings to support their bail order, and those findings are well supported by the evidence that those judges would have considered. This was not a juvenile who was arrested for trespass while in DCF custody. This was a child who had been in DCF custody for a number of years, picked up his vandalism and assault and battery charges, which were pending in the juvenile court, when he then ran from DCF custody and defaulted on those pending charges. He was a runaway in default for about 9 months, and during that time he allegedly fell in with a pretty rough crowd. On the date of offense underlying the charges for which he's held on bail, he was together with a drug dealer who accompanied him to a crack house or a flop house, where there was an argument over the cost of some crack cocaine, and the drug dealer that he was palling around with stabbed the would-be purchaser, threw him down the stairs, where the victim then collapsed in the street, bled out, and died.
So it may well be, based on the factors that you've alluded to, that the juvenile's not going to make whatever bail or conditions might be set. But I think I don't know, but I think what the juvenile is saying is that Brangen doesn't really work in the juvenile court as it relates at least to indigent juveniles or juveniles in DCF custody, because the analysis under Brangen of whether there's any less restrictive non-financial factor just doesn't work in that context. What's your response to that argument? They're not. I don't hear them saying change Brangen in the district court, the BMC, and the Superior Court. I hear them saying that I'm not sure that it works as it relates to showing non-financial amounts.
Well, I think the rationale of Brangen would essentially be that if the bail order, whether it's because of financial resources or in the context of juvenile court because they're in DCF custody and DCF does not post bail, if the bail order is going to amount to a de facto detention, the judge has, A, to clarify in their findings that, yes, this is my intention that this juvenile be held, and B, that I've considered the fact that DCF is not going to post this bail, or this bail is beyond the financial resources. But again, both judges in this case clearly understood the effect of the order. It would be a different case if, arguably they were like, well, I find, this juvenile under arrest for trespass, he has a summer job, he can probably make $50, but given DCF's policy that, the juvenile court can set that a bail is postable only by DCF, and they don't post any bail, that $50 unintentionally, under the judge's decision, amounts to detention. That might run into a problem aside from the financial resources prong of Brangen. But here, that's sort of not a live issue. The court's clearly understood that, we know he's in DCF, we know that he can't post this bail, but given the fact that he was in DCF custody and nonetheless was a runaway and in default for months and months, this high bail is necessary, because otherwise, if he's out, he's not going to come back to court, and there's very solid evidence on the record of that fact. So I think that's how the juvenile court would deal with the DCF problem. Just like I said, yes, I understand that this is going to hold the juvenile, and B, I've considered their financial resources and the fact that notwithstanding those financial resources, DCF is not going to post any bail no matter what.
Now, your sister contends that there was no indication of any colloquy to explore alternatives. Is that true?
My understanding, based on my conversation with the trial prosecutors, is that any comments the judge made on the record tracked their written findings.
Do we, by the way, have any record of the hearing?
Sorry?
Do we have, as part of the record, the transcript
We
of
do
the
not,
hearing?
no.
Okay, so we don't even have that.
Right, and I know that's not part of the record, but that's just my understanding, is that the hearing was consistent with the written findings. And I'm sorry, could you repeat the initial question?
The question was whether or not we have any indication from the colloquy during the course of the bail hearing, or that the judge explored other alternatives.
Well, I think in this case, it's pretty clear that those alternatives would not work in this case. I think the amicus, I tried to find the specific page number, but the amicus made the point that DCF has all-encompassing oversight of a juvenile in their custody with a variety of tools to improve the juvenile's condition outside of the juvenile justice system, to ensure their presence in court, to ensure their compliance with court orders. But that oversight clearly failed in this case. This juvenile was in DCF custody. He ran away from that custody, and while he was a runaway and default from pending a felony charge, he became an accessory to murder. Against that light, I think it's a pretty fair conclusion that DCF, with all of its tools and options, was insufficient in this child's case to secure his presence.
And when you say that he was in DCF custody for this child, what did that mean? Did it mean he had a foster parent? Did he mean that he was being held in some capacity?
I believe, and again, I know this is a part of the record, that he was in sort of a residential DCF kind of group home in Fall River, and I think that's where the initial charges, the pending charges, arose from. And then as a consequence of that, he...
Okay, but again, is that part of our record or not really?
It is.
Okay, so...
I thought I might have read someplace in the record that the juvenile wasn't likely to be adopted, and I think that might have come from the context of whether or not it's fair in this circumstance to consider lack of family ties. So if somebody's in DCF custody and they don't have parents available, they don't have family ties, do they start out with sort of two strikes against them? Are you aware of that argument that was made?
Yes.
Yeah. What's your response to that?
I do agree that's a factor that cuts both ways. I mean, it seems cruel to punish a child for a lack of family ties or a difficult family situation. But again, under Brangen and certainly even the pre-existing law around bail, that should be part of the individualized consideration that every child gets once they're the subject of a bail hearing. And in this case, when the juvenile defaulted from court, he didn't have a family to go back to. That's tragic, but the consequence was that he was on the streets of New Bedford, involved with drug dealing, involved with a homicide. So pretty serious stuff. So, I mean, I do agree it cuts both ways, but under the circumstances, it's a fair conclusion that DCF can't maintain oversight of this kid. There's no family that's going to take that role. He's already shown he won't comply with DCF or a pending court case. What's the alternative? And that alternative is to impose a bail he can't post, or that DCF can't post. But just to conclude, if there are no further questions, the judges in this case clearly gave the juvenile his individualized determination of his circumstances that's required by equal protection. The procedure complied with the requirements of due process. Given the evidence, it's clear that the child was a flight risk, that bail was appropriate, and even more so that bail he could not post was appropriate. If there are no other questions, I'd rest on the brief.
Okay, thank you.
Thank you.